Very, very discouraging. Another former top state official, pretty obviously guilty in my humble opinion, has the conviction overturned. Dean Skelos, a former state Senate Majority Leader, like the Assembly Speaker Sheldon Silver before him, has the conviction overturned. And we're joined by our legal analyst, Chas Farcher from Martin Harding and Mazzotti. Hey, Chas.
Good morning, Chuck. Good morning, Kelly.
Good morning. So, I mean, what this has to do with what the definition of bribery is or corruption is? Could you explain to us why these things keep getting tossed?
Yeah, and it goes back again to the theft of honest services law. This is a law that's been used to prosecute Joe Bruno nearly a decade ago now, then Sheldon Silver, and then Dean Skelos. And the Supreme Court has been narrowing the definition of what is a crime under this law for almost a decade. So with Joe Bruno at the time when he was originally charged and tried, you needed either a bribe, a kickback, or essentially the appearance of impropriety. After his conviction, the Supreme Court handed down a decision in the Skilling case and said, no, the appearance of impropriety is not enough. You got to show an actual bribe or kickback, and that was the basis of overturning his convictions. He was later acquitted. With Sheldon Silver and Dean Skelos now, they're tried and convicted, and the prosecutors think they have to show a bribe or a kickback, which they believe they've done, but the problem is the jury charge. When the jury is given instructions as to what a bribe or kickback is, it's money in exchange for an official act. What is an official act? At the time, the jury's charged that it's essentially anything done within the official capacity of these people. Now the Supreme Court has handed down a decision again in 2016 in the McDonald case and says, no, it's got to be more than any act. It has to be an official act, which is now defined as more than setting up a meeting or something like that. It's got to be pushing a contract through or something very specific.
Wow.
It just seems like what on earth do you have to do to get these people convicted and have it stick at this point?
Well, and I think, what's important to, it's key is that both Skelos and Silver appealed their convictions not only based upon the instruction to the jury, but also they said, listen, there's insufficient evidence to convict us. There's not enough evidence. And what's key is that the Second Circuit in both cases said, in light of the Supreme Court's decision, the jury instructions were wrong. They've been changed now. We have to give you a new jury instruction. But Second Circuit also noted in both cases that they found to be sufficient, or in Skelos' cases, maybe even overwhelming evidence of conviction. So it seems like retrial is certainly inevitable in both cases. It's just a matter of when.
Yeah, then the prosecutors say they will retry both. I'm wondering, well, under these new definitions where it's narrow definition of what's a bribe, what is a kickback, what do you think the likelihood is of conviction the second time around?
I think there's still very strong evidence to show it, and in fact, the Second Circuit in both cases went on to say that even though, the jury instruction was wrong, they could have found more than enough evidence with what was presented anyway to show an actual bribe, an actual kickback, to show an official act in terms of awarding contracts or pushing deals through. I think there's still plenty of evidence for conviction in both cases. The question is, when will you get there? Silver has now appealed the decision he won at the Second Circuit to the Supreme Court. He won on the issue of the jury charge, but remember, he lost on the issue of insufficient evidence. So he's now waiting for the Supreme Court to decide whether to hear his case. That looks like a stall tactic to me. And I think it's a safe bet to say Skelos' defense team will follow the same path. So you're probably looking at another 6 months, maybe a year before a retrial is even possible in both of those cases.
Wow. Let me ask you in a broader picture here with the number of different crimes. Okay, so say someone is convicted of a crime. Say they were, for example, convicted of drunken driving and they're in jail. And they say, hey, you know what? We're going to change. And they blew like a .09 or something. And the law says, hey, you know what? We decided, .08 is too strict. We're going to move it to .1. Does that person get out of jail, or is it what the law says at the time you were convicted?
Well, in some cases it can be retroactive. In some cases it may not be. It really is a case-by-case basis. The problem is that the law has kind of been in flux during the course of all of these cases. Usually it's what the law is at the time. But the problem with this particular case is the law hasn't changed. Really what's changed is the instructions that's given to the jury, whether or not someone is actually guilty. It's just a very convoluted issue because, what the court is saying is that not that the law needs to be changed, that the law as it was is unconstitutional. It's a bad law. It's not a later change in the law. It's that the Supreme Court is saying the way the law is written, you could potentially be convicted for doing anything, for an innocuous event. Sheldon Silver could be convicted for getting $100,000 to be a consultant for some of these people, and all he would have done in his official capacity is arranged for meetings. He would have allowed someone to meet with a contract or tell them who they have to talk to, but not actually done anything that would be considered a bribe. Or he could have been paid $100,000 to actually push through a contract and award it to somebody. There's no way to tell what the jury actually convicted on is the issue here.
We only have a few seconds left, and you're an attorney, not a politician, but do you think the law is skewed too far in the favor of the corrupt politician?
I think that, the The prosecutors had a great tool in the Theft of Honest Service Act to go after these people. I think the Supreme Court has whittled that law down over the last 10 years. I think still in both of these cases you have enough evidence to go forward, and I think they'll still use it in the future, but they're going to have stronger cases.
WGY legal analyst Chas Farcher, Martin Harding Mazzotti, 1-800-LAW-1010. Thanks a lot, Chas.
Thanks a lot, guys. Have a great day.
You too.
You too.
Thanks a lot, guys. Have a